You've probably seen videos on YouTube that talk about getting a patent for $50 or some low cost. Well, as you probably can imagine, those things are totally unrealistic. And so the question is, what does it actually cost to obtain patent protection? We're going to talk about that in this video. So obtaining a patent has several components in terms of what the cost is going to be. Those components are it would be good if I had some markers I could write. So in this video, we're going to talk specifically about utility patents. Some of these fees will also apply to design patents and patent patents, but we're going to take the approach of looking at the fees involved in filing and obtaining a utility patent. So the fees involve 6 main categories of fees. The preparation legal fees to get the patent application ready for filing in the USPTO, the USPTO filing fees themselves, prosecution legal fees as you go through the process of arguing for the patent claims that you want to get in your utility patent application. If you do get the patent application allowed, then you'll have to pay a USPTO issue fee to get the patent granted. And then after that, you have to pay maintenance fees, USPTO maintenance fees. So we're going to talk about each one of these fee categories and go into a little bit more detail of each one, and I'll give you some rough estimates of what these costs might be so you can get a better picture of what type of budget you need for filing a patent application. So to give you an idea of what these fees look like, and by the way, these fees come from the USPTO fee schedule, which is published on the USPTO website. And I will put a link to the USPTO fee schedule in the description of this video below. So you can take a look at that link and you can see the actual fee schedule. And that fee schedule changes from time to time. Sometimes the fees go up, but sometimes they actually go down. It depends on the funding that they have and different factors. But the fees sometimes can be lowered, sometimes they're going to go up. You do need to keep up with the most recent version of the fee schedule. So this table is based on the current USPTO fee schedule that was in force as of making this video, which is December 2023. And beyond that, these numbers might change. As I said, they might go up or might go down. So as you can see, the USPTO has different tiers of how you pay the fees depending on the size of the entity that you qualify for. A regular large entity like a Fortune 500 corporation is going to pay large entity fees. If you're a small business entity, you're entitled to pay small business entity fees. And if you can qualify as a micro entity, you can pay the micro entity fees. To qualify as a micro entity, you have to meet certain income requirements. And these requirements are also specified on the USPTO website. And I'll also put a link to the microentity status qualification information in the description of this video below, so you can take a look at that as well. But the microentity status, if you're able to qualify for that, provides significant reduction in the USPTO fees. If you take a look at the total fees, the 3 basic fees you have to pay upon filing an application are the basic filing fee, a search fee, and an examination fee. Now, subsequent to that, as I mentioned, if the patent does get granted, then you have to pay an issue fee. And after the patent is granted, there are some maintenance fees that you have to pay, and those are based on the grant date of the application, and they're 3.5 years out, 7.5 years out, and 11.5 years out. So it may be that you don't pay all the maintenance fees because if the patent turns out to be not valuable or if you're not gaining sufficient revenue from that patent, you might decide at some future date not to pay the maintenance fee, and in that case you'd let the patent go expired. But assuming that you were to keep the patent in force all the way to the term of the patent, then the numbers I have at the bottom, I don't know if you can see them well, hopefully you can, but that gives you the total cost, just the fees, just the USPTO fee cost for maintaining a patent from filing it through getting it issued and paying the maintenance fees to keep the patent in force. So a large entity is paying over $16,000 today in order to do that. As a small entity, you're paying close to $7,000 to keep the patent in force after you've gone through filing and prosecution. And for a micro entity, you're paying over $3,000. That's, again, this is just the filing fee, the issue fee if the patent doesn't get granted, and the maintenance fees to keep the patent in force. What about the legal fees involved? So if you've done any kind of project management in the past, and if you're an engineer, I'm sure you've dealt with this before, but in order to discuss the legal fees for development of a patent application, we really need to think about this in terms of the quality triangle. And what is the quality triangle? So in an ideal world, you want something done fast, low cost, and high quality. But in reality, you can only have two of any of those three items. So if you choose fast and high quality, you're going to end up with high cost. If you choose fast and low cost, you're going to end up with low quality. And if you choose low cost and high quality, you're going to get it done, but it's going to be low priority and probably have a very long lead time because whoever's producing it isn't going to put a priority on it because of the cost factor. So taking that into account, you have to look at the different models that different law firms might provide for you in terms of how they price preparation of a patent application. Now, some firms will provide a flat fee option, others will provide hourly. And maybe you can get an hourly rate up to some capped fee. That might be another possibility. But let's just think about this in terms of flat fee and hourly rate. Now, what I've found in my law firm experience is that if you are able to get a flat fee, that might sound good on its face, but you have to look closely at what's really going on with the flat fee. So most law firms take the approach that their employees, meaning their associates, they have partners and associates. The partners are usually shareholders in the firm that get a portion of the revenue that comes into the firm as income. And associates are usually paid a salary, but they're required to produce a certain number of hours in the firm. Typically, when you go to a law firm, they're going to have partners and associates. You may talk to a partner initially about your patent case, but more likely than not, the application is going to be assigned to an associate in the firm. Another thing to be aware of is that there are different types of law firms. There are general practice firms that do everything under the sun in terms of legal work, and they have an intellectual property department that also does patent law. That's one type of firm you may encounter. Another type of law firm you may encounter is a boutique type law firm. By boutique, I mean a law firm that specializes in a certain area of law. In our case, we're talking about an IP boutique, a law firm that specializes in intellectual property law. And some IP boutiques specialize in patent law only. They may not do trademark or copyright law. They may only do patent preparation and prosecution. So these are the different firms you need to be cognizant of when you do your search for a patent attorney or a firm to work with you and your business. So from the standpoint of an associate in a law firm is usually required to work a minimum of 2,000 billable hours. Now, the 2,000 billable hour requirement is an average, and some firms may actually require more than that. Some may require 2,200 hours, maybe even more. There may be firms that require less. A general practice firm, in general, is going to require their associates to do about 2,000 billable hours. And whether they have a different regime for patent practitioners is something that you might be able to find out. But usually the general practice firm is going to treat all associates the same, and they're all going to have the same billable hours requirement. So how they get paid, whether they get a bonus, and whether they do good on their performance review is really going to depend on them making that 2,000 billable hours by the end of the year. Let's say that firm is giving their clients a flat fee for patent application preparation, and the patent applications are being assigned to an associate that has this 2,000 hours billable requirement. Well, in most cases, the way that associate is going to think about that work is like this. Let's just say, for the sake of argument, that associate in the firm has a billing rate of $400 an hour. In some of the larger firms, that is actually the case. So if they're assigned flat fee work and they have a 2,000 hour billable hour requirement, they offer you a flat fee of $5,000 for preparation of the patent application. So let's say that firm offers you a flat fee of $5,000 for preparation of your patent application, and then that patent application is assigned to an associate in the firm. Well, that associate is going to think of that patent application as the flat fee divided by whatever their hourly rate is at that moment. So let's say that their hourly rate is the hypothetical $400 an hour. they're going to think of that application as $5,000 divided by the $400 hourly rate, which gives them 12 and a half hours to work on your patent application. Now, depending on what the patent application is and depending on the level of experience of that associate, the 12 and a half hours may be sufficient to prepare a high quality or at least a decent quality patent application on your behalf. But if it turns out that associate isn't very experienced, 12 and a half hours to get your patent application completed may be a challenge for that associate. And so they may be spending more than the time allotted. Maybe they have to do that in order to get the work done. But if their law firm is going to limit them to that budget based on their billable rate, they're going to have that 12 and a half hours. And so their motivation to get it done is going to be high, but their motivation to produce something of high quality is not necessarily going to be as high. And this is just a reality that you have to face when dealing with law firms, especially if you're going to a larger firm and especially if it's a general practice firm. Now, there are exceptions to this rule. This is not a hard and fast rule. I'm just giving you an example of how some associates are going to have to think about this work. This is just the reality of law firm life for most associates and for a lot of patent practitioners, unfortunately. Now, you may go to a patent boutique, and the boutique may have a much lower billable hour requirement for their associates. Maybe their associates have a 1,500 or 1,800 billable hour requirement. If they do, it may be a little bit easier for them to be a little bit more flexible on the time that they spend working on applications, and it might be easier for them to do a lower flat rate patent application and still produce it at a high quality without getting a detrimental impact on their performance review with the firm. In general, a patent boutique or an IP boutique is going to have a better understanding of what it takes to produce intellectual property work like a patent application. Now, that doesn't mean that a general practice firm won't have that understanding, but what I've found through my experience, this is anecdotal based on my experience, other people may have had different experience. What I'm telling you is that in general, a general practice firm is probably not going to have as much sympathy toward their patent associates as an IP boutique that is intimately familiar and understands what it takes to produce a high quality patent application. So let's say you go with an hourly rate. If you go with an hourly rate, well, that same $400 an hour can add up very quickly if that associate is spending an inordinate amount of time on preparing your patent application. But let's say that it's a partner or a very experienced senior associate that's done a lot of patent applications, really knows your technology, knows your product line. In that case, doing it hourly may actually wind up just as economical as paying a flat fee because they may be able to produce that application in a small enough number of hours at the hourly rate that it's still a somewhat reasonable cost for production of the patent application. But again, this $5,000 number I'm giving is just an example number, and this number could vary based on the complexity of your application. Maybe some firms can produce a patent application at less than this, and maybe some law firms would produce it at more. The point that I'm making to you is that shopping to different law firms might not be a bad idea if you've never filed a patent application before, so at least you get an idea of what those fees might be, what the fee structure is, whether you're going to pay a flat fee, whether you're going to pay an hourly fee, and whether an associate that has experience is going to work on your application or it's going to be assigned to somebody that has little experience with supervision, hopefully by a partner that understands more than the associate does. But you just have to find that out by talking to the firm. You have to communicate and get information. You have to find out how they structure their fees and who's going to be doing the work on your application. Now, the situation I'm describing here is at a large firm where there's 20 or more associates or enough associates that you don't really necessarily know who your patent work is going to get assigned to. But if you go to a smaller firm like an IP boutique or an individual attorney, well, then that problem goes away because you'll communicate directly with the attorney that's doing the work on your application, and you'll know a lot more about how the work is going to get done, hopefully. And so there are different options that you have. A lot of large corporations, the large entities that I showed you before, they use general practice firms for different reasons than you might select a firm if you're a smaller entity or a micro entity. For example, if that company is doing a lot of litigation, if they're doing a lot of patent litigation, or they have other legal matters like employment law issues, labor law issues, contractual issues, and other litigation that that firm is handling for them, then that may be their preferred firm to work with, and it may be independent of whether they're a general practice firm or not. They're just using that firm. And because that firm is handling all their legal matters, they're also letting them handle their patent prosecution matters. So this is something that needs to be understood when you look at firms and you see who's prosecuting patent applications for what companies. This is one of the reasons that some larger companies go with larger firms, because that firm handles a larger portfolio of legal work than just their patent prosecution work. So to summarize, what I'm saying here is you need to look at the different types of firms that exist and decide what type of firm you maybe want to work with. You may want to work with a general practice firm. You may want to work with an IP boutique. You might want to work with a smaller shop that has a solo attorney or a smaller number of attorneys that you can interact more directly with, rather than going through a partner and then having that partner farm the work down to an associate who you may or may not be able to communicate with depending on how the firm is structured. But in terms of the cost, you're going to encounter either flat fees or you're going to counter hourly rates. You may be able to get hourly rates with a capped fee. So the two other cost items on the list that we haven't talked about yet are the prosecution legal fees and the prosecution USPTO fees. So prosecution legal fees are going to involve responding to office actions, and that might involve making amendments to the claims. That's where you're going back and forth with the examiner and arguing about the claims that you should be entitled to and arguing against prior art that the examiner has cited. Now, in most patent applications, on the average, you're going to have about 2 office actions. In the past, there were a lot more office actions. Often that would be sent out. Sometimes you could have 3, 4, 5 office actions. But nowadays, they're trying to do what they call compact prosecution, and they're really trying to do a better job on the initial office action so that there's less back and forth. And on average, what I've found is that today you're going to get about 1 or 2 office actions before you get to what's called the final office action, or you get to issuance of the patent. So office actions, responses, and amendments are going to have some attorney time. They can take anywhere from an hour to prepare up to 8 hours, maybe even longer, depending on the complexity of the office action. So that's an unknown. The other thing that the patent attorney or the patent attorney's paralegal or assistant will have to do from time to time is file information disclosure statements. You may need some type of petitions. There may be an appeal to the Patent Trial and Appeal Board at the end if you get a final rejection that you don't agree with, and that's going to be the legal fees involved in the attorney drafting an appeal brief. Now, prosecution fees, the good news on prosecution fees is usually there are no prosecution fees unless you file an IDS that's called a supplemental IDS. There's a small fee for filing an IDS after the initial filing of the patent application. And if you have to take extensions of time. So when you get an office action, typically you have 3 months from the mailing date of the office action in which to respond. If you respond after that, you can take extensions of time, but you can't go over 6 months. 6 months is the statutory limit. So usually you have 3 months to reply, and you can take up to 3 months of extension of time. However, each month costs more than the previous month. So the first month may be $100 or something like that. The second month goes up, and the third month goes up substantially. So if you're taking a lot of extensions of time on patent applications, that cost can add up. Now, another side note, it's also not recommended to take extensions of time because taking extensions of time delays the prosecution, and that can have an adverse impact on your patent term. We're not going to talk about the details of that in this discussion, but just be aware of that. You really don't want to take extensions of time unless you really, really have to. It's really necessary. You really need more time to think about the response to that office action or how you want to amend the claims. But in most cases, 3 months should be sufficient in order for your attorney to come up with a sufficient response to that office action. So what are examples of costs on the prosecution side? It's hard to say because there is uncertainty as to the complexity of any office action, but just for the sake of argument and discussion and for budgeting purposes, Let's say that an office action response costs $3,000 and you're going to have 2 of them. So in this table, I put some estimated numbers and some numbers from the actual USPTO fee schedule. The numbers for the legal fees, of course, are the estimated numbers because we really can't know what type of cost you're going to get for preparation of the patent application, and we can't really know what the cost of the office actions is going to be. So I'm just making the assumption that you can get an application done for $5,000 and that you'll have 2 office actions, and the cost of responding to those office actions will be about $3,000 each for a total cost of $6,000. I'm going to assume that for prosecution, you don't take a lot of extensions of time, but maybe you had to file a supplemental IDS and maybe you had to do 1 extension of time. So let's just estimate that at about $500, just so that we have some ballpark numbers so you have an idea of what the budget is that you need to get a patent application through to allowance and to maintain it. So I've broken this table out like I did in the initial table that I set up for large, small, and micro entity. And you can see I rounded the numbers up after adding up the columns. And the approximate numbers for a large entity is going to be about $30,000. For a small entity, about $10,000 less. You can maybe get by with about $20,000. And for a micro entity, you can do a little bit better and do that for about $15,000. But basically for a small and micro entity, you can see that you're going to be in the ballpark of about $20,000 with today's prices. And that's estimating that you can get an application for $5,000. Maybe you can't get it for that price. Of course, maybe you can get it for a better price. But the point is that you have to have a basic understanding of what the cost is. And so if you've seen a video on YouTube telling you that you can get a patent application done for $50, you know that that's absolute nonsense, because the patent application filing fees alone are going to run, well, as you can see, they're going to run into the hundreds of dollars. So these are not exact numbers. These are just to give you kind of a ballpark understanding of what it costs from the initial preparation of the patent application, filing it, prosecuting it, getting it allowed, and then having to pay the maintenance fees at the end. And of course, the maintenance fees, you might not pay all the maintenance fees depending on how valuable the patent turns out to be, and you may not find that out until later, and you may make a decision not to pay all the maintenance fees. But in general, that said, if you're going to keep your patent alive for the entire term, these numbers are, at least today, a ballpark number that you can use for budgeting purposes, that you're going to need at least that much to get the patent through the patent office and then maintain the patent through its entire term. So this doesn't take into account patent cooperation treaty filings and other foreign filings that you may want to do. So if you want to do filings like that, other fees are required, and the cost starts to go up immensely as you do foreign filings, because then not only will you have the filing for local counsel legal fees, but you'll have the local patent office fees in the countries in which you're filing. And so that can add up the cost to your overall portfolio significantly. However, if you have a very valuable patent and you're going to be licensing it worldwide and using it worldwide, then it may make sense to have foreign filings on the application in addition to the USPTO filing. So these are all things to think about. I hope you found this video helpful. I know there isn't a lot of information on patent cost out there, and so I really wanted to give you some numbers to kind of get a feel for what the actual cost is so that you really understand what's involved in it. And if you found this information helpful, I hope that you'll subscribe to my channel. I'm planning a lot more good stuff to come. And if you know anybody that would benefit from the information in this video and you can share the video with them, I would also appreciate that very much. So that's all I have for today. Stay inventive, and I'll see you in the next video.